After 3 years of marriage, Ariana Grande is getting divorced. And allegedly, she has $240 million. And after her divorce, she gives her husband, and I will say only, after 3 years of marriage, she gives him $1.25 million, half of the sales proceeds of their real estate, and $25,000 towards his attorney's fees. How is it even possible? Well, the prenup. They had a prenup where I would assume, because it's not public record, that he wouldn't get any alimony, he would get some lump sum of money, and they have been going through a settlement. And the reason I assume they had to go through a settlement because of case of appeal that came out in 2023. Last case, LAST versus Superior Court. In that case, the court said that the prenuptial agreement is presumed to be not valid until the court states all 5 factors of the Family Code section 1615C. What are the factors? Let's dive into it. The first factor is, and the umbrella of that is, the agreement is presumed to be signed involuntarily unless, number 1, the other side has been represented by counsel. Well, what if the other side didn't want to have a lawyer? Then they should have been advised in a separate writing, so it cannot be part of the prenuptial agreement, in a separate writing to seek an independent counsel. Then they waive it. And factor number 2, the advisement, if the agreement was signed before 2020, needed to be 7 days prior to signing. So there is the 7-day prior to signing, advising to get an independent counsel, presenting the final draft of the agreement, and then the signature date, right? So the 7 days is very important. The legislature passed another law, which is part of this 5 factors, that agreements that are signed after January 1st, 2020 only need 7-day period from the time the final agreement has been presented to the other side and the signature date, independent of whether or not this other side is represented. So this is very complicated, because number 1 factor says if someone was not represented by legal counsel, they need to waive it. And then after 2020, if let's say they were not represented, then all they needed is to get a final draft 7 days before signing. And what is final draft? Final draft is defined where no substantive changes are made, meaning between the date it has been presented, the 7-day, and the final date of signing, errors such as typos can be corrected. That's not going to invalidate the agreement automatically. But substantive changes, for example, flipping regarding spousal support. Spousal support, yes versus no spousal support. Division of assets, things like that affecting financially the whole deal. The third factor is if the other side has not been represented by an attorney and they waived the representation, then here's the thing. They need to receive an independent memorandum of understanding regarding what they have signed. And this opens a whole Pandora box. Who is going to send them an independent memorandum of understanding? The lawyer who drafts the agreement? That's a problematical issue, because the lawyer who drafts the agreement has only a duty to the client to advise about legal consequences of the agreement. The lawyer who drafts the agreement, if they send an independent memorandum of understanding, it could be construed as legal advice and could be a big ethical issue. And who is going to say that this memorandum is fulfilled or complete? In all prenuptial agreement cases, I wouldn't even take a prenuptial agreement if the other side is not represented, because it just, as you can see, creates a whole different complication factor. Fourth factor, the Prenuptial agreement cannot be signed under duress or fraud. Duress could be, we're inviting a big family member wedding and 150 people, and then 2 weeks before the wedding, he or she gives him the final version of the prenuptial agreement they never discussed. Well, some people could feel pressure because a lot of money is invested depending on their assets. It could be a lot of factors where duress could be construed. How to avoid this? Just make sure to take a deep breath and present the agreement at least 3 months before the wedding. So the other side has an option to seek a truly independent counsel who practices family law to truly participate in some negotiations. And as a flip side, if the other side is negotiating the agreement, then already the duress factor is not so valid because the other side has the option to negotiate, and specifically if you accept these terms of negotiations, that already really is a good sign. And the final factor is really stressing me out as a lawyer. It's any factors deemed relevant. It's open-ended, meaning I'm going to repeat the umbrella word. The prenuptial agreement is presumed to be not valid unless, and then any factor deemed relevant. It leaves the court a lot of room for interpretation. So even if the prenup seemed to be valid at the time of signing the agreement, 20 years later, if there is a huge discrepancy and someone is disabled or something different big happened in their financial and health-wise life, it could mean the prenup could be invalidated. So that case just cemented what was already in place in Code Section 1615. So my overall sense of how to negotiate these agreements, prenuptial agreements, first, have your lawyer drafting it, have the other side also have a lawyer, disclose, negotiate, make sure that the agreement is balanced, is not completely unfair, meaning you get everything, the other side doesn't get anything if they don't have any assets, and offer attorney's fees, offer some good deal at the time even of enforcement of the agreement, because you don't want to leave it up to court. If you like the video, click like, subscribe, comment down below, and if you have any ideas for my next videos, I would really appreciate it. Have a good day. Bye!